Hey there, I'm estate planning attorney Paul Rabley. And in this video, we're going to talk about 5 mistakes that people make with their revocable living trust plan. All right, so before we get into the mistakes that people make, we got to talk about what is a revocable living trust or a living trust plan. So let me ease into that by saying most people are familiar with the concept of a will or a last will and testament. It's kind of the traditional and customary way. It's the way that you see it in movies where people talk about their will. So people write a will, they leave all of their assets in their name. When they pass away, their will names an executor to oversee the settling of the estate, and the will declares who's entitled to inherit assets of the person who died. So that's all fine and dandy, but what some people perceive as a real big problem with leaving their estate to their heirs that way through a will is when you die with assets in your name, not all assets, but some kinds of assets, which we'll talk about. When you die with assets in your name, they're frozen when you pass away. And so when you have assets in your name and that will governs the disposition of them, there's this probate, court and attorney involved probate proceeding required where the survivors and the executor hire lawyers and everybody goes through a court process. A judge gets involved to declare that the will is valid. A judge gets involved to approve things and order the distribution of those frozen assets to the appropriate heirs. And so many people perceive that probate process as being very expensive and time consuming and just an all around hassle. And maybe they perceive it that way because in many cases, quite frankly, it is. So now let's talk about the alternative as we talk about the 5 mistakes people make with a revocable living trust plan. Some people, in an attempt to avoid their survivors from having to go through that court and attorney involved probate process, they set up what's called their revocable living trust. I'll talk about this hypothetical married couple called Kermit and Miss Piggy. I've used all the other hypothetical examples in other videos, Fred and Wilma Flintstone, Mike and Carol Brady, and all the others. But here we're going to go with, for the first time ever, Kermit and Miss Piggy. So Kermit and Miss Piggy, let's say they have a couple of children or whatever it is that Kermit and Miss Piggy would have, but we'll call them children for now. They have 2 children. And they'd like to make the estate settlement process easy for everyone. So Kermit and Miss Piggy set up the Kermit and Miss Piggy Revocable Living Trust. They name themselves as the trustees of the trust as long as they're alive. They name the survivor of them as the trustee of the trust after one of them passes away. And they name someone, maybe one of their adult children, as the successor trustee to handle the distribution of the trust assets after both Kermit and Miss Piggy pass away to the appropriate beneficiaries that are listed in the trust instrument. Kermit and Miss Piggy designed all of that, very likely with the help of an estate planning attorney. Okay, and then in addition to that, in addition to creating their trust, the key to avoiding probate is transferring assets to their trust, assets that are already titled in the name of the trust. When Kermit and Miss Piggy pass away, they don't have to go through that court and attorney involved probate process. So they sign some paperwork and it gets recorded in the county or parish records where Kermit and Miss Piggy are transferring their home and other real estate from Kermit and Miss Piggy to Kermit and Miss Piggy as trustees of the Kermit and Miss Piggy Living Trust, or however it's called. Same thing with their LLCs. Their trust becomes the member of the LLC. Same thing with their brokerage accounts, retitled from Kermit and Miss Piggy to Kermit and Miss Piggy as trustees of the Kermit and Miss Piggy Trust. Now, when Kermit dies, for example, and depending upon how they set up their trust, it's very possible that when Kermit dies, Peggy doesn't have to do anything. She just stays in control of all of the assets. She doesn't have to deal with lawyers and court processes and frozen assets. She just stays in control of all of the trust assets. And then when she dies, really right away, that successor trustee that they named can start settling things, dividing the assets up, maybe sell the home if that's appropriate, immediately without having to wait and go through the time and expense and delay of that court and attorney involved probate process. So that's the short version of the revocable living trust plan. Why do people do it? Essentially, there's a few other reasons, but essentially most people create it because they want to keep their survivors from having to go through that court-involved probate process. Okay, and oh, by the way, if Kermit had an IRA or a 401k account, he would not put that in his trust because he has assets like 401ks and IRAs and life insurance that are what are commonly referred to as non-probate assets. Kermit named beneficiaries on his IRA, maybe named Miss Piggy as the primary beneficiary, maybe named his children as the contingent beneficiaries. So even when someone creates their revocable living trust, they often have certain assets that don't go into their trust because those assets avoid probate by their nature. Okay, so that's the idea behind the revocable living trust. Does it work perfectly every time? Of course not. Do people make mistakes? Of course they do. Let's talk about what some of those common mistakes are. Okay, so the first mistake that we see, I'm going to call it the failing to fund the revocable living trust. I'm going to call that the mistake. Some people say, what does funding a trust mean? Well, funding a trust means titling assets that are in your name, taking them out of your name and transferring them into the trust name. I mentioned before, Fred and what's his name? Kermit and Miss Piggy had a home. And so when they created their trust, they transferred their home from Kermit and Miss Piggy to Kermit and Miss Piggy as trustees of the Kermit and Miss Piggy Trust. That's titling the asset into their trust. That's funding their trust. And they did that with their brokerage accounts, their LLCs, and their other, what we commonly refer to as probate assets. And I will tell you, most people do a pretty good job of that when they do it when they're setting up their trust. They're setting up their trust. There's a conversation about what are their assets. There's a conversation about funding their trust. There's often paperwork prepared and signed exactly at the same time that their trust is signed, transferring assets to their trust. So it's pretty standard to get the funding correct when you set up your trust. And I've been doing this long enough where I've seen many, many people, thousands of people create trusts and then subsequently passed away. And I've seen when things have gone very smooth, and I've seen when there's some glitches. So a failing to fund is one of those glitches. And a common area where I see that is when people create their trust and they fund their trust when they create it, but then they acquire assets after they create and fund their trust, and they make the mistake of not titling those assets in the name of their trust. So people have come to me before and said, 8 years ago, Dad set up his trust, but 2 years ago, he bought a new piece of property, but he didn't buy it in the name of the trust, which is what he was instructed to do. He just bought it in his own name. So he didn't fund the trust with that piece of real estate. And another common example is sometimes people who have a trust will receive an inheritance. They might receive a brokerage account. They might receive a home or a piece of land. And so they receive that inheritance in their own name. And again, they neglect to actually transfer that over into their trust. And so they pass away. Those assets are not in their trust. So they have to go through that probate process in order to get those assets. And again, it's just those assets that are not in the trust that have to go through the probate when they pass away. Still, all of the assets that were funded in the trust can kind of sail through to the beneficiaries outside of any court and lawyer involved process. Okay, so that's a big one. Another one is, and I'm going to say this kind of lightly, failing to update the trust. Although I think many people or most people don't have to update or amend their trust when they think they do. Let me give you an example. We've created so many trusts over the years. And so when people are creating their trusts, they're like, well, Paul, what's involved with amending my trust if I buy a new home? Paul, how do I get in touch with you or your office if I open a new business and I want to put my business in the trust? Or what if I open a new brokerage account in the trust? Well, in just about all of the cases, acquiring new assets like real estate, businesses, brokerage accounts doesn't require an amendment to the trust. There's some exceptions that I'll talk about here in a minute, but most trusts don't list all of one's assets in the trust. Most trusts say, for example, that that parent, unmarried parent who has 3 children, that trust instrument of that unmarried parent may just say, when I pass away, all of the trust assets go to my children equally. And none of the trust assets are, quite frankly, listed in the trust instrument. The key is, though, that assets need to be titled in the name of the trust. So if you have a trust and you buy a new house, you don't need to go back to the lawyer and amend your trust. You just need to buy the house in the name of your trust. Same thing if you start a business. Same thing if you open up a new brokerage account. Just open that account in the name of the trust. Kermit and Miss Piggy as trustees of the Kermit and Miss Piggy Living Trust. The lawyer or any lawyer who created the trust doesn't have to amend your trust. Now, here's the exception. Let's say you do open a new business and you title it in the name of the trust. So the trust is the LLC member if the business that was being formed is an LLC. And if you want a specific person, for example, to inherit that business when you pass away. So you don't need to amend your trust to title your business in the name of the trust. But if you do have 3 children and you want that oldest child who works with you in the business to inherit 100% of your business when you pass away, then you need to amend your trust to say, when I pass away, I want, all of my membership interest or all of my shares and whatever to go to, that one child who you want it to go to, instead of falling under what I'll call the residuary clause, which is something like everything else in my trust that I didn't mention goes to my 3 children equally. So that is an area where a trust amendment will need to be prepared to make sure a specific asset goes to perhaps a specific person. Okay, next issue for mistakes made with the revocable living trust plan is not coordinating your trust with the other necessary estate planning legal documents. I'll talk about a couple. First thing I'll mention is the pour over will. So a pour over will is a will, but when it's coordinated with a living trust, we call it a pour over will, because if Kermit has 2 children and his trust says, when I die, I leave my assets to my children equally. Well, we always, when we create Kermit's trust, we also create a will. We may never use the will, especially if Kermit's trust is funded to keep everything out of probate. But we have that pour over will there just in case there is an asset in Kermit's name when he dies. So that pour over will is likely going to say something like, or the effect of it is something like, if I die with something in my name that's not in my trust, I direct in my will that asset or those assets be poured over into my trust. However, we want to avoid that circumstance if we can, because that probate is necessary to transfer the title of that asset that was in Kermit's name when he died to his trust. So we want to get that coordinated. The other thing I've seen some kind of funny stuff is when someone, when we create a revocable living trust, we also do these, we'll call them powers of attorney. Very, very common. Pretty much everybody, when they get their legal affairs in order, they do these powers of attorney. And then there's healthcare documents, but I'll talk about the financial or general or property power of attorney. So you have to coordinate that with your trust. So, for example, Kermit and Miss Piggy may say that the successor trustee, the trustee to handle trust assets when Kermit and Miss Piggy die, or when one of them dies and the survivor of them is incapacitated, they may designate someone as the successor trustee of their trust. And then in addition to naming a successor trustee of a trust, they also established a power of attorney. Of course, Kermit named Miss Piggy first, but Kermit also named a backup to Miss Piggy on the power of attorney. So when someone with a trust becomes incapacitated, it gets a little tricky, because the successor trustee handles trust-related matters, when the trust settlor is incapacitated. And the agent under the financial power of attorney handles non-trust related matters. So, for example, if Kermit had an IRA that was not in the trust and shouldn't have been in the trust because it's a non-probate asset, and Kermit is incapacitated and he can't sign anything to take a distribution that was needed from his IRA, well, the power of attorney controls that. But if Kermit's house needs to be sold, that's a trust asset. And so the successor trustee will handle the management and perhaps sale of that asset if Kermit's incapacitated. So sometimes people say, well, let me name this person as the successor trustee and this person on the power of attorney, two different people, but I want to give everybody a role. Now you've got different people handling different things when one person becomes incapacitated. Just be aware that that's an issue. Okay, then the next area where people make mistakes is they forget about handling those beneficiary designated assets. A lot of people go through a lot of work to create their trust, to create their pour over will, to create their powers of attorney. They're dealing with lawyers, they're dealing with meetings, they're paying legal expenses, they're having to deal with titles of real estate, ownership of businesses, titles of brokerage accounts. And so there's a lot to handle when you create, that estate plan to try to make things really simple for your survivors in the future. And more than a few people have neglected to deal with their non-probate assets when they're going through getting their estate legal affairs in order. For many people, their largest financial asset is their IRA, and it's a non-probate asset. And so while people work with the lawyers and work with the professionals to get their trust set up and get their trust funded, sometimes they neglect going back and revisiting their beneficiary designations on their IRAs, their 401ks, and their life insurance. They just kind of assume that the trust would control all of that, and that's a false assumption. So let me give you an example. Let's say Kermit goes through the whole estate planning process with the lawyers, and he decides, makes a big decision. He's got 3 children. He's going to leave 40% of his estate to one child and 30% of his estate to another child. He's going to leave only 10% to a third child, and he's going to leave, I think that leaves 20% to be divided among his grandchildren when he passes away. So he does all that. He feels really good about it, but he neglects to deal with his IRA and his 401k and his life insurance to the extent he has all those things. And he doesn't go change the beneficiary designation to accomplish what he was trying to accomplish with his trust. So he passes away, and then you have to go to those beneficiary designations who were not updated, can cause a big mess. All right, and then perhaps the fifth and final mistake that people make with their revocable living trust is they fail to communicate. And so they fail to communicate the existence of their trust, and they fail to document or communicate the assets that are subject to the trust. Now, look, I get it. A lot of parents will set up their estate plan and say, I don't want my survivors, I don't want my kids, I don't want my grandkids to know what I've done until after I pass away. People have the right to do that. Other people say, no, let me go ahead and communicate, let everybody know what my wishes are, let everybody know what I've done. That way we can hash it out and there won't be any surprises in the future. But the problem comes when somebody dies and nobody knows of the existence of a trust. Nobody knows where it is. Nobody knows where the original pour over will is. Nobody knows where the powers of attorney are. And of course, you're incapacitated. You can't tell anybody. Nobody knows what assets are in the trust. So they have to go kind of on a wild goose chase to try to figure out what somebody owned, and it makes that estate settlement much more difficult. Okay, so there you have it. 5 different mistakes people make when they create their living trust. Hope that helps. And, we'll see you next time.